Greetings and welcome to my lecture on Chapter 7 on the topic of employment law primer and employment law primer for career counselors. So overview, we're going to look at a couple history things as well as some summaries of employment laws that as a career counselor will be really important for you to know so that you can be able to advocate for clients regarding career counseling topics as necessary, as well as really just educate them on what their rights are, right? So let's get into it. So why Frank Parsons cared about employment law. So his career path included direct experiences in the worlds of the haves and have-nots. And those experiences motivated him to be an advocate for social justice, even including 20 years as an attorney. To help address what are called employment law issues now. And late in his career, he turned his attention towards career development needs of the middle and working class citizen. So for the history of employment law, there's an entire contract approach and at-will employment doctrine, the legalization of collective bargaining that occurred through the National Labor Relations Act of 1935, and passage of laws that led to the narrowing or limiting of at-will employment doctrine. So transition from the entire contract approach to the at-will doctrine occurred during the Industrial Revolution. Under the entire contract approach, workers were only paid after completing the entire contract. And if they quit or were fired, they didn't get paid, which is wild to imagine. And the at-will employment doctrine was established to allow for indefinite time period for employer-employee relationship, where the employer has to pay employees for whatever time has been worked. And this at-will doctrine remains dominant in the United States today. Okay, so initially at-will employment was meant to serve to benefit the employee because it required payment for the time worked. However, many abuses of the at-will system resulted in consistent advantage inconsistent advantage for the employer because individual workers who addressed concerns about working conditions often experienced retaliation or got fired. And so that created a need for new ways to balance the rights of employees and employers through labor unions, collective bargaining, and employment laws like FMLA and different things like that. So labor unions were illegal and considered criminal conspiracies until 1842 and 1935 in the United States. They provided protection for workers from employer retaliation because they could collectively rather than individually broach issues of concern. Compensation and working conditions were also main foci of those labor unions, some of which still exist today. As for employment laws, they are meant to serve employers and employees, and there are 4 types that are related to hiring, firing, work conditions, unemployment or inability to work, and life after retirement. So for hiring and firing, there's immigration law, employee background checks, non-discrimination laws, wrongful discharge exceptions to at-will employment, and advance notice to layoffs that are important to consider. So, when you're working with people in career counseling, you want to be mindful of whether or not there's anything in their background check that needs to be known. Actually, something really cool that I will put a link to in the description of this video is a link to felon-friendly employers. Having worked at probation, I found that was a need for a lot of the guys that I worked with, a lot of which lost their jobs because of their DWI or other charges that they might have incurred during whatever happened that got them on probation. So yeah, I will absolutely provide that to you. And then looking at wrongful discharge exceptions and advance layoff. So immigration law. This regulates eligibility for employment in the United States for immigrants, and it requires all employers with 3 or more employees to verify eligibility through an I-9. Dates and specific laws relevant to immigration law, primary law, Immigration Reform and Control Act, and the Immigration Act of 1990. So those were significant in building up immigration law to where it is now. As for employee background checks, this is looking at laws pertaining to types of background checks that are legal for employers to conduct for employees. So reference checks, criminal history, credit history, health history, depending on what the job is, they can ask for these things. And like I said a minute ago, I will put the link to the felon-friendly employers in the description of this video. And I just pulled the link up on the side to remind myself to include it. So employee background checks, that's just something that some clients are like, why do I have to do this? It's so stupid. Da, 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 da. Well, if a job wants to require that you have to do a background check, it's just part of the process. I'm sorry if that's a frustrating thing for you, but maybe we can look for a different job that doesn't require a background check. Is that something you prefer to have happen, right? And also you can even look at what are they willing to disclose, or are they willing to affect their credit score in order to have a certain job, and things like that. Do they have references, helping them develop references, things like that, helping them understand that. You can also, looking at reference checks, usually these are legal, but for employers that are unwilling to do more than verified dates of employment, that can be because they're worried about being sued, or maybe they got fired at the last job and they don't want to. So while they're legal, many former employers are unwilling to do anything more than verified dates because they don't want to be sued by the employee that left that place because maybe they're saying too much, or what have you. So, or defamation of character and all those different kinds of things that can be charged. So things to be considered. But even if a client you're seeing doesn't have any references, you can work with them to develop what could be references, or write their resume even for how they can navigate that issue if they don't have any. Maybe it's their first job, so they don't have any references. And it can turn into needing character reference. And so they use their aunt or their uncle or something like that. As for criminal history, it's legal in many states and required for some occupation choices. So a key issue, criminal records include both arrests and convictions. So hiring decisions should be based not only based on the arrest history, because there's a disparate impact of that. Employee background checks, they can also look at credit history. The American Bar Association considers that questionable, and it can be disparate across different racial groups and might be even in violation of the Fair Credit Reporting Act. I've never seen a job that required running your credit score. I don't know what kind of jobs would require that, but it's just something to know that could happen. And then health history, HIPAA prohibits use of protected health information, which is called PHI. And it's illegal for an employer to use genetic information for employment decisions. So interestingly, there are some questions that are illegal for interviewers to ask you during an interview. So are you married? Do you have kids? What are your health problems? Things like that are very intrusive on your personal life. And so doing some reading, doing some learning, even educating clients on those types of things can be really useful for helping them in career development process. Non-discrimination laws are relevant to prohibition of hiring and firing. And these are some different laws for clients to know about. For the Civil Rights Act of 1964 is the granddaddy of all employment laws. So this prohibits the refusal or failure to hire any individual or the discrimination against any individual with respect to compensation, terms, conditions, or privileges of an employment because of that individual's race, color, religion, sex, or national origin. Two primary forms of discrimination involve disparate treatment and disparate impact. As exceptions to this law, it does not apply to employers with fewer than 15 employees. However, many states have anti-discrimination laws that do apply to those kinds of employers. This federal law allows an employer to hire employees of a specific gender, religion, or national origin, but never race or color when the business necessity requires it. So an employer must document that one of the factors is a bona fide occupational qualification, a BFOQ. As for the Discrimination in Employment Act of 1967, this federal law prohibits discrimination against individuals of age 40 or older, and there's no federal protection against employment discrimination against people younger than 40. However, some states have laws against age discrimination that extends to all ages. Americans with Disabilities Act was passed in 1990 and amended in 2008. It applies to the private and public sector and prohibits employment discrimination against individuals with disabilities, and it requires that reasonable accommodations be made for such individuals. So like, for example, I have a client that I would think would meet criteria for autism spectrum disorder, or a disability based on low IQ. And she had no idea that she could go to the HR at her place of employment and request accommodations to make her job a little bit easier by getting accommodations. She had no idea. No one had ever told her that. And that's part of how I advocated for, is I helped her write the email that she could write to HR. I helped her write email to her boss, and we practiced what she could say and how she could ask it, things like that. So yes, the individual employee has the burden of demonstrating qualification, and they are considered qualified if they can perform with reasonable accommodations. So can they do the job if reasonable accommodations are made, like they're given additional time to do a task or what have you. As for the Rehabilitation Act of 1973, it also prohibits discrimination based on disability, but it focuses on protection of federal employees and those people who work for employers receiving federal funding. And the laws, again, include Title VII of the Civil Rights Act of 1964, Age Discrimination and Employment Act, Americans with Disability, ADA, and the Rehabilitation Act of 1973 as amended. So is substance abuse a protected disability? Yes and no. It is only a yes if the individual is currently abstaining. It is a no if they are currently using an illegal substance, or if the use of the substance interferes with the individual's ability to perform the job, or the substance use represents a threat to property or the safety of others. How about with sexual orientation? Is discrimination against sexual orientation legal? Yes. To date, there's no federal legislation prohibiting discrimination on the basis of actual or perceived sexual orientation. However, the U.S. military repealed the Don't Ask, Don't Tell in 2011 to regulate conditions in which individuals can be discharged on the basis of sexual orientation. So no, such laws do exist, however, in a number of states and localities. So wrongful discharge exceptions, the basic concept of at-will employment is an employee can quit for any reason, an employer can fire an employee for any reason, for a good reason, bad reason, or no reason at all. 89% of employees incorrectly believe an employee can be fired with just cause, and it's not true on a federal level, and there are some exceptions that protect employees against wrongful discharge. There's statutes with exceptions, statutory exceptions, contract exceptions, and common law exceptions. So some states with exceptions, only Montana and Arizona have state laws requiring just cause for the termination of employees. And as for statutory exceptions, they're based in laws that limit an employer's right to fire a person for bad reason or no reason at all. And it's involving these different characteristics that they would be fired for. There's table 7.2 in your book is something that you can look at. Contract exceptions. So some employment contracts specifically limit the at-will employment doctrine, collective bargaining agreements, union contracts, express contract, and they express a contract between the employer and the employee. As for common law, it refers to specific court cases in which the court has found a firing unacceptable, and this finding then sets a legal precedent. So exceptions, they might have an implied covenant of good faith and fair dealing. There might be implied contracts like employee handbooks, tort claims, public policy claims. And you can see more about that in table 7.4 in your book. Advance notice of layoff. So the Worker Adjustment and Retraining Act was a federal law passed in 1988 that pertains to mass layoffs. So employers that have 100 or more employees have to put in writing any notice or any upcoming layoff that affects 50 or more people within 30 days of time. Now looking at work conditions, there are laws specific to hiring and firing, as well as laws focused on work conditions. And there are 4 types of employment laws. We're getting to number 2 here with the pertaining to work conditions, which protect workers from discrimination and harassment at work, as well as inhumane or unsafe working conditions. So again, those laws that we already covered, in addition to prohibiting discriminatory hiring and firing, these laws prohibit discrimination with regard to working conditions like pay, promotion requirements, work schedules, and complaints are handled by the EEOC. Some other laws that pertain to discrimination and harassment issues are the Equal Pay Act of 1963, Lilly Ledbetter Fair Pay Act of 2009, and Civil Rights Act of 1964, which prohibit discrimination and require equal pay, extended period of time for filing for discriminatory pay with the EEOC, and also looks at the quid pro quo and hostile work environment as forms of sexual discrimination and harassment. Fair Labor Standards Act was also passed in 1938, as well as the OSHA was passed in 1970, in an effort to improve work conditions and make sure things were safe, not working too long, not working in really unsafe conditions, like there's no AC or it's really hot or it's freezing or, no fire exit, all these kinds of different things, right? Some of you may remember the Chicago fire that happened in, I think it was the 30s. It was the Shirtwaist Fire of 1930 something, I believe. But the Fair Labor Standards Act, so federal law passed in 1938, regulates minimum wage and establishes the 40-hour work week as full time. And it requires hourly workers to be paid overtime or time and a half if they work beyond that. And it also limits the type of work that children are allowed to do, and the number of hours that they're allowed to work in order to reduce child labor issues, right? OSHA was passed in 1970 to make healthful work conditions for all workers. It protects them also in the form of providing research, information, education, and training in an effort to improve workplace safety. And workplace fatalities have decreased 60%, and occupational injury illness rates have decreased 40% as a result of OSHA's work, which I think is wonderful. As for unemployment and inability to work, in addition to employment laws specific to hiring and firing of employees and laws specific to work conditions, there are employment laws pertaining to unemployment or the inability to work. Third one here, that's our third form of the 4 employment laws. So 5 major types of employment related to unemployment and the inability to work. So you've got COBRA, which is an extension of eligibility for healthcare benefits. So like if you get laid off or you quit or you leave, COBRA can be a coverage of health insurance that you get between jobs. I've been offered that before, but I had another job lined up when I left the job that offered that to me. So I haven't had to use it. So I don't have a lot I can say about COBRA other than it's coverage for your healthcare for between employment when you're employed to cover the gap. Unemployment insurance, workers' compensation, vocational rehabilitation, and Social Security disability insurance. So looking at COBRA, COBRA is actually an act, Consolidated Omnibus Budget Reconciliation Act of 1985. And it addresses healthcare needs of people who lose their employer based on group healthcare plans. So if you're working somewhere like I was working at probation, and your employer's offering you health insurance and you lose your job or you leave your job, they give you 60 days to decide whether or not you want to keep your benefits for up to 36 months. Oh yeah, it says it down here. It can be maintained up to 18 months and sometimes up to 36 months if there's a death or divorce from the employee who had the insurance. Just to bridge the gap of your health insurance so you have coverage. So it can be a really good thing if you need it, but from what I remember, it can be a little bit expensive. Under unemployment insurance, there's no federal law. Instead, insurance programs are run by states, but paid by state and federal monies. So there are variations, but a number of commonalities across them with time lengths and the recipient being able to do work. But the thing is, it's available only to those individuals who are unemployed by no fault of their own, which can vary state to state. Workers' compensation, despite progress related to OSHA, nearly 4.3 million people suffer non-fatal workplace injuries and illnesses at an annual cost of more than $156 billion as of 2006. I would be really interested to see what that number looks like now, especially with the advancement of technology and people starting to work more from home. I wonder if those damages have gone down potentially. But worker compensation is legislated legislative program designed to assist workers who suffer work-related injuries or illnesses. It's meant to replace income that they've lost. So yeah, why does this matter? We want clients to know, hey, this is an aspect of a job that you want to look at. As workers' compensation, something you're going to have to potentially worry about if you're going to go work on an oil rig versus at a factory sewing something on clothes, or working in a toothpaste factory, or working as a receptionist somewhere. Is needing workers' compensation something that you want to try to avoid? Is it something that you've had to deal with before, right? It's just, again, something where you're potentially educating clients on their rights. As for vocational rehabilitation, it's part of the Rehabilitation Act 1973. The RSA was established by Congress to administer a wide variety of programs to assist disabled individuals in a number of capacities, including vocational rehabilitation, support, employment, and independent living. So clients that are eligible might have lifelong disabilities or acquired disabilities that either were related to a job or they might have happened independent of work. Also, SSDI, Social Security income, or Social Security Disability Insurance, excuse me, a federal program designed to assist people who are unable to engage in gainful employment due to disabilities. So they could be lifelong, they could be temporary, or they could be acquired off the job or on the job. It must be expected to last at least 12 months and prevent the person from gainfully working anywhere in the country. If they can do any kind of work, they're not the same type of work prior to the disability, the person will not qualify for SSDI or Social Security income benefits. So they have to have insured status, and if they're 32 or older, must have worked 5 of the last 10 years and paid Social Security contributions for at least 5 years to be able to benefit from them. So that's something else for clients to know. If they acquire a disability, you can help advocate for their insurance or for their income if that is warranted. You also want to make sure you don't confuse SSDI and SSI, like I kind of just did on the last slide. SSDI is established by Title II of the Social Security Act, and it's a workers' insurance program for people with disabilities that prevent employment, versus SSI is needs-based for people with disabilities that prevent being able to work. So it's a different, it's an income rooted in inability to work versus the other one's insurance. So that's just important to know. 7.7 has qualification, table 7.7 has qualification requirements in your text. And lastly, life after retirement. So in addition to employment laws specific to the hiring and firing of employees, to work conditions and employment or inability to work, there are employment laws pertaining to life after retirement, which is the 4th type of employment law. So Social Security and pensions, also the Employee Retirement Income Security Act. So looking at Social Security, excuse me, it was established in 1935. Social Security was initially called Old Age and Survivors Insurance. Prior to this law, there was literally no federal safety net for employees. So when they retired, they had only 2 sources of income, either their savings or a pension given by an employer. So Social Security added another source of income for people who participated and met eligibility standards. So to be eligible and collect Social Security after retirement, people must have worked for a participating employer. The states of Maine and Illinois do not participate in this program for state employees, and they have to have worked for at least 10 years and made contributions to Social Security. So the amount of retirement income, of course, is based upon how long one works, how much one earns, and how much they contribute, as well as the age at which they retire. Some employees also count on employee-based pension plans, which can either be a defined benefit or a defined contribution. So the benefit would be a guaranteed monthly income based on a specified amount, versus the contribution would be they might match an amount that is taken out of your paycheck and put into a 401k, for example. And upon retirement, you get the lot of whatever's in there. So like when I worked at probation, they had a vesting that they did after 8 years of working there. So they put 7% of every paycheck into a savings account. And after working at the county for 8 years, you would become vested, which is where they match whatever is in that account 200%. So if you have 10 grand in there, they're giving you 20 grand. So pretty cool little reward program. I didn't stick around long enough to see that. I was only there for 2 years. But yeah, there's really cool stuff that the jobs can provide. And that might be something that's a really important for your client who is seeking employment. They want to have a 401k, they want to have such benefits be part of what they're getting from it. And lastly, the Employee Retirement Income Security Act is a law that regulates private but not federal or state pension plans to ensure that retirement benefits promised to employees are actually provided to them upon retirement. So making sure you get that money that you pay for, or that you paid in rather. So, these are all different things you can consider applying to that original cast of clients that you learned about in chapter 1. And think about how might these different laws or limitations or expectations or requirements apply to those different casts of clients. So again, I'm going to put the felon-friendly employers list link into the description box of this video. And thank you for joining. I'll see you in the next one.